participants, including our interpreters here. And again, thank you for the cooperation. So in accordance with the committee's routine motion concerning connection tests for witnesses, I'm here to say that informing the committee that all our witnesses today online are in compliance and we're ready to go. I just wanted to mention, because it's been the case in the Heritage, I'm just going to flag it because 2 weeks today we asked for the agreement from the University of Ottawa. I've asked a couple of times, I've asked the clerk, and we still haven't received it to my knowledge. The department officials were here 2 weeks today. They came with only French scripts on the agreement. I asked then for the English version. We still haven't got it. And I think it's pertinent that we've had 3 out of the 4 committee meetings, including today, to have the English agreement. And I would like to see that by Monday, May 6th at the latest, so that we can go through at least those that don't follow French as well as maybe we should. But I would like to see that the department officials, as of Monday, May 6th, have the English agreement from the University of Ottawa in our hands. The other one that I just want to flag is Bell Media. They were here some 2 to 3 weeks ago. We've asked for documents. I would like those documents by Monday, also May 6th, and here's the reason. Because on May 7th, we have, I think they've agreed to come, the president of the CBC, Ms. Tate, and a number of us would like those documents from Bell Media to maybe compare public-private agreements that we could ask on Tuesday. So I don't think it's too much to ask. We've had 2 weeks in advance on the one dealing with the court challenges program, and with Bell Media, it's been at least 3 weeks. And Clerk, I would like to see if we could get those documents by Monday, May 6th, so that we can finish next week dealing with the CBC on Tuesday and then dealing with our court challenges program next Thursday. So that is me personally asking that you get those documents, and if we can get them by Monday, May 6th, which would really help prepare us for next week, if you don't mind. So that's me personally.
Point of order, Mr. Chair?
Yeah, Ms. Ashton, go ahead.
Okay, I'm raising a point of order because just in terms of our list of witnesses today, I see that we have one witness, Mr. Brody, who's been invited back, and I'm wondering what led to this situation. We had 5 witnesses last week who were all impacted by delays in terms of technicalities. None of them have been invited back, and I'm wondering how we got to this point, and I'd also like to express concern regarding this situation.
Okay, Ms. Ashton, I do know that the clerk did not have a full agenda for witnesses today. Since we only went through one round last Tuesday, Mr. Brody has agreed to come back today. He will not do a 5-minute like he did on Tuesday, so he will be here to answer questions only. There's no need for Mr. Brody, the professor at the University of Calgary, to go through the 5-minute that he would normally do if he wasn't here. So he's just agreed to Ms. Ashton to answer questions that maybe weren't asked to him on Tuesday because we only did them one round. Can I ask a question? Yes, Mr. Koto. Well, just hold on. Yeah. Ms. Ashton, is that fine?
Well, it's not fine because while I appreciate the 5 minutes won't be shared, all of our witnesses, including the only NDP witness, the main witness we invited last week, also did not have a second round. So I am concerned that we are not fair in the treatment of all of our witnesses from last session, and would like to extend that to all of our witnesses, frankly, at this point. I've actually never seen something like this happen before in my 16 years of being on committees, so I don't actually. I'm quite concerned that we've shown a lack of fairness, and also reflecting the fact that our we don't all have the same number of witnesses that we suggest. So
I'm going to let the clerk, thank you, Ms. Ashton, for bringing this up. I'm going to let the clerk answer this. We were talking just seconds ago, so if you don't mind, clerk, just the clarification on Mr. Brody.
It is certainly up to the committee how they would like to move forward with additional witnesses. For Mr. Brody specifically, the party that put him forward had requested to re-invite him since they had more questions, and he counts as one of their witness slots.
Okay, Mr. Koto?
Does that mean there's more than one witness who's with us today that were invited specifically by the Conservative? Is just the only witness?
Yep. Yeah, Mr. Noor Mohammed?
Mr. Chair, I am concerned because I had questions I wanted to ask to the organization out of British Columbia and a couple of other of the witnesses that were here. I'm not sure how this played out in terms of us deciding. I'm still speaking. I have the floor, Ms. Thomas. No, you weren't. I mean, you have a reputation of...
Whoa. That's enough. Point of order. That's inappropriate to attack someone's reputation.
Before I finish my sentence,
Hold on.
we're going to use the word wacko.
Okay,
Is that the clip you needed, Philip? Is that the clip you needed?
Hold on.
You just got
hold on.
yours, so.
Yeah.
There you go. There's
Point
the
of-
wacko clip for the day. Whoever's
Okay,
got that on the
Mr.
bingo
Noor
sheet, mark it
Mohammed,
up, guys.
please. Mr. Noor Mohammed.
I had the floor, Mr. Chair.
Yeah,
It'd be
but
great if I
there's
could-
been a point of order here by Mr. Lawrence. I'm going to deal with...
Apologize.
Let's hear the point of order, Mr. Chair, please.
We hear the point of
Yes.
order, please.
It is unparliamentary to impugn the reputation.
Point of order, Mr. Chair.
You can't point of order a point
Well,
of
if
order.
you're gonna
you
accuse
can't
me of
order a
impugn-
point of order.
you're
You're
gonna-
going to ruin the. You're going to
This
hurt
is
the
your clip?
interpreters.
Is
Do
this
not
the clip
crosstalk,
right
sir.
here? This
Do
is your
not
clip?
crosstalk.
Is this the clip you need?
can't point of order. Point of order. Do not crosstalk. You are breaking the rules, sir, and you are hurting the interpreters.
Mr.
You
Lawrence.
care about somebody other than
Okay,
yourself,
Mr.
remarkable.
Noor Mohammed, we'll give the floor to Mr. Lawrence here, and then if you wish, we'll go back to you. So, Mr. Lawrence, please.
That was completely inappropriate to like, it's childishness. He's rolling his eyes. He's saying that I don't care about anyone else but myself. Like, this is childishness. To impugn the reputation of another honorable member is unparliamentary. It's in the Green Book, and you should apologize and withdraw.
Mr. Noor Mohammed.
Mr. Chair, I invite you to look at the blues to see what I actually said before you. You've heard. You didn't even let me finish my statement.
Point of order.
Right. So, did you hear what I said, Mr. Chair?
I didn't.
Okay. So, I invite the clerk or anybody to go back and hear what I said, because I actually wasn't allowed to finish. Ms. Thomas, in the middle of my comments, started to speak at me, then made an assertion while speaking to me that she was speaking to her colleague. So, if you'd let me go back to what I was saying at the beginning of this, I'd appreciate that.
Fire away.
Thank you, Mr. Chair.
You don't have to ask Mr. Brody any questions.
No, I understand that, Mr. Chair, but there were other witnesses that we wanted to ask questions to. To selectively bring one witness back, and Ms. Ashton makes a very good point, to bring back one witness so that we then have one witness, and then what are we going to do with the rest of this meeting? Are we going to go to clause by clause? I'm not sure. What is the plan for the rest of the meeting? So are we going to end the meeting after that round?
No, we have, several guests here, and we're going to hear them.
Okay, so
and
the
then we'll
question
go
earlier was,
around.
do we have other witnesses? And the answer was no. I think that's where the confusion resides.
Well, can we go through our witness list today?
So do we- so
starting with 5 minutes, it will be EGAL Canada
Okay,
first.
so we do have other witnesses. Just to
I
confirm.
have in front of me, Mr. Noor Mohammed, I have 4 groups in front of me,
I
along
understand.
with Mr.
Chair,
Brody.
the question earlier that was asked is, what do we have else? And the answer that Mr. Koto got was that was it.
We've got him right in front of us. Can we go ahead and do our meeting?
So, I mean, if Ms. Ashton's point has been addressed and she's going to have an opportunity to find time for her witnesses, I think that's reasonable.
Okay, we'll go ahead with today then, if you don't mind me chairing this. EGAL Canada is with... did you have your hand up? Okay, Ms. Thomas, sorry.
Sorry, there's been quite a bit of drama. Thank you. There's been quite a bit of drama around this table. Look, I think the clerk made it really clear. Each party around this table gets a certain allocation of witnesses. Conservatives decided to bring one witness forward twice. That counts as 2 slots. If other parties wish to bring one witness forward for 2 slots, they are welcome to do the same. I'm not sure why there is such venom being exchanged at this table when those rules equally apply to all parties.
Thank you, Ms. Thomas. We'll move on. So with us today, Mr.
Excuse me.
Sorry, Ms. Ashton, you have your hand up, yes?
Yeah, just quickly, if we're going to throw words around, and I am certainly not here for any of this. I mean, the word venom, I like. I mean, I just honestly, quite honestly, this committee is quite something. I think what I would say is the person who initially brought up this point of order is this option has was not made known, I guess, to those of us who also didn't get to fully hear from our witnesses, recognizing that we have proportional time, obviously given party status, and so my concern is while I appreciate your using your slot, my concern is that we also didn't hear from our witnesses, and in the case of the NDP, our main witness fully as a result of the time change, which obviously impacts your witness. So, you know, I stand by my concern, appreciate that you used your slot again, and certainly would appreciate that we not use words like venom to characterize legitimate points of order that people raise. My goodness, I believe we're above that.
Thank you, Ms. Ashton. You, of course, know we also have a meeting next Thursday to invite your people back if you didn't get the one that you wanted back here on Tuesday and Thursday. Ms. Latenzio?
Thank you, Mr. Chair. May I suggest perhaps that next time, if we do get in the situation of adjourning a meeting because of a call of a vote, and obviously that cuts into the testimony of certain witnesses, can we perhaps maybe have the clerk advise the parties as to whether or not they want to re-invite those same individuals for the next meeting, the subsequent meeting, or at another meeting, so that this does not happen again?
We tried to extend the meeting. It was quite late with Ms. Ashton asking the questions. We got 6 o'clock, and then shortly we had till 7 o'clock. We actually had the room till 7 o'clock, but I hear what you're saying. Okay. Mr. Saray, you had your hand.
Yeah, non, Monsieur le Président, moi je suis nouveau. Donc,
I'm new at this committee here. I've been a parliamentarian for 8 years, and I've never seen a witness come back twice without the committee's consent. There was no discussion with other members of the committee. Usually, there's better efforts made to inform committee members. That's all I wanted to mention, Mr. Chair, to ensure that there's a dialogue between all parties.
Okay, thank you. Can we get to our guests that are all on video conference today? From EGAL Canada, Mr. Bennett Jensen, who is Director of Legal, the Fédération des Associations de Juristes Expression Française de Common Law, Justin Kingston, who is the President, and Renaud Remillard, the Director General, from the Fédération of Community Francophone des Acadian de Canada. Sorry about that. Leanne Waugh, I believe, President. You're with us video conference. And from the Canadian Bar Association, Jennifer Canor, the Chair, Access to Justice Subcommittee. So when we get to you, you have 5 minutes to give your opening statements. Justin and Renaud, one of you, or you both can go, but you have to share your time of 5 minutes. Mr. Brody, as we said, you've already stated your 5 minutes, so you will be available for question and answer. So we'll start with Mr. Jensen from EGAL Canada. You have 5 minutes to address the Heritage Committee here this afternoon. Thank you.
Thank you very much, Mr. Chair, and good afternoon, everyone. My name is Bennett Jensen. I use he, him pronouns, and I'm the Director of Legal for EGAL Canada. EGAL is Canada's leading 2S LGBTQI organization. Founded in 1986, EGAL has been at the forefront of advancing and defending the rights of 2S LGBTQI people since that time. Particularly in the early years of the Charter, the Court Challenges program was essential in EGAL's ability to obtain legal recognition of queer people. I appear today on behalf of EGAL in support of Bill C-316. I will be addressing 3 brief points. The first is the role of the Court Challenges program to date. The second is the particular vulnerability of 2S LGBTQI people. And the third is the need for a robust challenge function in a healthy democracy. On my first point, as members of this committee likely know, Section 15 of the Charter does not expressly list sexual orientation as a prohibited ground of discrimination. This protection was obtained through the courts. Courts reasoned that sexual orientation was analogous in nature to the immutable characteristics protected under Section 15, such as race and religion. This recognition was achieved through litigation. Specifically, the Court Challenges Program provided funding for EGAL's interventions in landmark cases such as Rosenberg in Canada, Egan in Canada, and M&H, which led to the recognition of same-sex relationships, and specifically the conclusion that Section 15 prohibited discrimination on the basis of sexual orientation, a finding that has enabled broader acceptance and dignity for queer people in Canada. Currently at EGAL, we are grateful to have received Court Challenges funding to pursue protection for the rights of another historically marginalized community, intersex people. EGAL has initiated litigation challenging provisions of the criminal code, which permit unnecessary surgeries to so-called normalize the appearance of intersex infants' genitals in violation of their charter rights. On my second point, the members of this committee will also appreciate that litigation is very expensive. For equity-denied groups, the very discrimination for which they require legal services is often a factor in their ability to afford those services. 64.5% of 2S LGBTQI people in Canada earn less than $40,000 a year. Discrimination in housing, employment, and education contribute to higher poverty rates. Courts and human rights tribunals in this country have recognized that gender diverse people in Canada in particular are in a unique position of disadvantage. On my final point, in order for the Charter to play its part in promoting equity and justice in Canada, those in minority communities must be able to access the courts to challenge the constitutionality of legislation passed by the majority. The Court Challenges Program is the vehicle that makes this more possible. I note that this is a politically neutral position. The rights guaranteed by our Charter apply to all. When the legislative branch of the government fails to protect the charter rights of marginalized social groups, litigation is the avenue by which the government can be held accountable to its obligations. Without financial support for litigation, this avenue is closed to groups relying on charter claims to overcome systemic and systematic discrimination. This is a crucial moment for gender diverse people in particular. By gender diverse, I mean two-spirit, trans, non-binary, and gender non-conforming people. As elected governments and major political parties take aim at the rights of gender diverse people, particularly the rights of young people, it is essential that our communities are able to access the justice system. As the Supreme Court of Canada recognized last year in Hansman and Neufeld, a core disadvantage facing gender diverse people in Canada is the politicization and denial of legitimacy of trans identities and lives. This is precisely the kind of disadvantage that demands well-functioning checks and balances within our legal and political systems. In conclusion, EGAL strongly supports the strengthening of the Court Challenges Program through its entrenchment in legislation. This will help counteract the financial difficulties faced by equity-denied communities, including ours, in asserting their charter rights before the courts and ensure that all of us benefit from the protections of our Constitution. Thank you.
Thank you, Mr. Jensen. We'll move now to Mr. Kingston and Mr. Remillard. You have 5 minutes. You can share your 5 minutes, or one can take the entire time. It's up to you. Go ahead.
Merci, Monsieur le Président. Je m'appelle Justin Kingston.
Thank you, Mr. Chair. My name is Justin Kingston. I'm the chair of the Fédération des Associations des Juristes d'Expression Française de Common Law, also called FAGEF. Mr. Remillard is the Director General and is also online. The FAGEF wants to promote access to justice in French in the provinces and territories in Canada. We work with lawyers in the different provinces. The FAGEF also has members from Francophone organizations in the 3 territories, in Newfoundland and Labrador, and in PEI. We are also a member of the FCFA that is also here today. The FAJEF supports Bill C-316 for different reasons. Firstly, a court challenges program is essential to ensure access to justice. Here are some examples of concrete impacts of different cases supported by the CCP. Francophone schools were created in 3 provinces and 3 territories and 6 provinces, including Saskatchewan, Alberta, and BC. 28 school boards exist now, and 7
Online is not getting translation, I'm hearing, and we're going to just stop. We stop the clock here for you. You still have 3.5 minutes. We'll pick it up in a moment, but we're just hearing the floor, and we're not hearing translation. So proceed, if you don't mind, for 3.5 minutes.
Merci.
Thank you. Courts have recognized the right to education, which led to the creation of Francophone school boards in Canada outside of Quebec. Courts also recognized legislative rights. Secondly, over the coming years, the CCP will be essential to ensure the implementation of the new Official Languages Act. This is a quasi-constitutional act that was adopted with the support of all parties in 2023. The new act will include certain ambiguities, and eventually there will be the need for the courts. This is fundamental because in a democracy, independent judges have to interpret legislation. Thirdly, in the case of language rights, an individual should not have to assume the financial costs alone. This could cost hundreds of millions of dollars to defend a collective right. And so public funding is essential. Fourthly, Anglophone Canadians living in provinces and territories where English is the main language have benefits. It's an invisible benefit. It's the force of numbers. And in the adverse case, it disadvantages Francophones in those regions. There's not the same support for both groups. Fifthly, promoting language rights is essential. There are positive economic impacts. For example, if in a majoritarily English region, there needs to be support for Francophones so that they can fully integrate as well. Also, it is positive in case any government would seek to undermine language rights. There needs to be the financial support. Furthermore, a court challenges program offers Francophone communities some legal support in order to promote their language rights. And that is important considering the government would have significantly more resources than they do. Thank you.
Thank you, Mr. Kingston. We'll go now to the Federation of Communities Francophones, Leanne Waugh, the president. Leanne, for 5 minutes, please.
Monsieur le Président.
Mr. Chair, members of the committee, good afternoon. Thank you for inviting us to appear before you today with our colleagues from the FAGEF. The FCFA is the national voice of 2.8 million French-speaking Canadians living in minority situations in 9 provinces and 3 territories. Our organization leads a national network of some 900 French language organizations and institutions across the country. Our communities are determined to live in French and work hard to do so every day. Over the years, they have built more than 700 French language schools, some 20 French language or bilingual colleges and universities, health services, community and cultural centers, and media outlets. These institutions didn't appear out of thin air. In many cases, we had to go to court to obtain or defend their existence. While the Canadian Charter of Rights and Freedoms has established clear language rights, respecting these rights has proven to be quite another matter. In many cases, in many parts of the country, it took years of legal recourse. In 1984, a group of Franco-Albertan parents took legal action because they felt the charter gave them the right to manage their own schools. They took their case all the way to the Supreme Court, where they won in 1990. So 6 years later, I would like to talk to you about Summerside and PEI, where children had to take a 2-hour school bus ride every day to attend school in French. After years in court, the Acadian parents won their case in 2000. And what about the 5-year court battle to save Montfort Hospital, the only French language teaching hospital west of Quebec, from closure? And finally, the long and recent struggle of the Fédération des Francophones de la Colombie-Britannique to ensure that it can once again provide Francophone employment services in the community. The Court Challenges program is the pillar on which these victories rest. It's thanks to the program that there are now 42 Francophone schools in Alberta today. It's thanks to the program that disputes over French language education in the territories that are still before the courts today can continue. It's important to understand that legal challenges are not a simple process. They require time and resources over several years. These are individuals and groups who simply dream of being able to live in French for themselves and for their children. Dedicated people who take on these battles, demonstrating immense bravery and tenacity to defend the collective rights of their community. It was the Court Challenges program that enabled these people to go all the way. I can tell you without a doubt, if our communities are alive and kicking today, it's due in no small part to all the cases we've been able to pursue thanks to this CCP. It is to these cases, and therefore to the program, that we owe many of the institutions that enable us to live in French as promised in the Charter. That's why the FCFA has always defended the program, because we know only all too well how closely its existence is linked to what enables us to live in French. The program is linked to our Francophone sense of belonging and identity. Today, our communities are increasingly diverse. Just as Francophones continue to face barriers to language rights, so too do many Francophones now face discrimination based on race, sexual orientation, or gender identity. Living in French is about language and human rights. And the Court Challenges program is more important than ever. That's why we're here today, resolutely in support of Bill C-316. Thank you for your time, and I will be pleased to answer your questions.
Thank you, Ms. Waugh. Right on time. And the final one for 5 minutes from the Canadian Bar Association, Jennifer Kaur, the chair, Access to Justice Subcommittee. So, Ms. Kaur, go ahead for 5 minutes, please.
Thank you, Mr. Chair, and thank you to the committee for the invitation to be here today. My name is Jennifer Kaur. I use the pronouns she, her, and I'm the Canadian Bar Association's chair for the Access to Justice Subcommittee. I'm pleased to be joining you today from the traditional unceded territories of the Mi'kmaq and Wolastoqiyik people in Nova Scotia. The Canadian Bar Association is a national association of 38,000 lawyers, Quebec notaries, law teachers, and students, with a mandate to promote improvements in the law and the administration of justice. The Access to Justice Subcommittee strives to improve and promote access to justice for poor and middle class in Canada. The Court Challenges program has experienced a series of cancellations and revivals which underscore the program's inherent instability, emphasizing the necessity of an independently administered program. The Canadian Bar Association is a longtime supporter of the program's objectives to advance constitutional rights and freedoms by funding test case litigation cases of national significance in the areas of equality and official language rights. In fact, the Canadian Bar Association recommends the expansion of the program's mandate to also include equality challenges with national implications to provincial and territorial laws, policies, and practices, claims of discrimination by historically disadvantaged groups under the Canadian Human Rights Act, and dedicated resources for Aboriginal and treaty rights and federal responsibilities to Indigenous peoples. Governments have significantly more resources at their disposal compared to individuals or advocacy groups. This resource asymmetry can manifest in various forms, including access to legal expertise, financial resources for litigation, and institutional support. As a result, individuals and smaller organizations face significant barriers when attempting to challenge laws or government policies in court. In 2006, the Canadian Bar Association passed a resolution with respect to the Court Challenges program. In that, we asserted that it is a fundamental premise that the Canadian Constitution and our system of justice to be effective, rights must be able to be exercised. The clarification of constitutional rights benefits all Canadians, and the Court Challenges Program has a vital role in increasing access to justice for marginalized and vulnerable groups. And the program makes a unique and important contribution to democratic values and citizenship, particularly given the rising costs of charter litigation and complexity of such litigation. In the CBA's 2013 Reaching Equal Justice report, which sets out a plan to create a more accessible and equitable legal system, the CBA called for a rights culture where individuals and groups are empowered to know and enforce their rights through strengthening legal capabilities. In 2016, when the CBA commented on the proposed reinstatement and modernization of the program, we stated that the program should be run by an organization independent from government. Ultimately, a stable, well-funded program is one that can hold the government accountable for its actions by providing a mechanism and a more level playing field through which individuals can challenge laws that may be unconstitutional or infringe on their rights and freedoms. This helps to maintain a healthy balance of power between the government and the people it serves. Enshrining the Court Challenges Program into legislation ensures more equitable access to justice for all. Thank you.
Thank you, Ms. Kaur, from the Canadian Bar Association. So each party has the first 6 minutes. Up first will be the Conservative Party. Mr. Gord, for 6 minutes, please.
Merci, Monsieur le Président.
Thank you, Mr. Chair. My first question will be for Mr. Ian Brody. I would like to start by thanking him for all of his work with the previous Conservative government. He is a very good advisor, a very high caliber advisor, and offered advice to a Prime Minister who left Canada in good standing in 2015. I would like to thank you sincerely, Mr. Brody. Now that said, the National Assembly in Quebec adopted Bill 52, and it's a bill that follows Bill C-21. This bill seeks to renew the provision for the courts and religion. There are currently 4 associations in Quebec that have stated wanting to go to the Supreme Court to counter this bill. I believe that these organizations would be eligible for the CCP. Do you believe that it is fair that federal money would be used to counter provincial legislation on secularism?
Thank you for the question. I just want to clarify, although I appreciate the members' comments off the top here. I'm here not in my previous political capacity, but because of my longstanding academic work on the Core Challenges program. In the written submission that I sent to the committee a week or so ago, I think I set out that it is a continuing problem of the Core Challenges program to have a federally funded organization funding challenges to provincial legislation. I have a long-standing view on the propriety of using the federal spending power in areas of provincial jurisdiction, and I extend that view to this issue with the Core Challenges program here. If the federal government decides, the current one or some future one, that it wants to intervene in the court case in order to bring additional legal arguments before the courts. Of course, it's always open to the Attorney General for Canada to intervene in a court case and to bring public interest arguments before the court. But to be in the business of effectively subsidizing and encouraging court cases against provincial legislation, or for that matter, municipal actions here, I think is a violation of the principles of the spending power.
Monsieur Brody, selon votre connaissance,
According to your national and international knowledge, are there any other countries that have looked to the CCP? If so, how? And if not, how do other countries deal with similar cases?
I should say, Mr. Chairman, when I travel internationally, I'm often asked about this because of my academic work on the Court Challenges Program, and I have difficulty explaining to either legal activists or to government officials in other countries how it came to be that the federal government pays organizations or individuals to sue it in court for these kinds of rights issues. There's a long tradition of public interest litigation challenging legislation and government action in the United States and in other countries. This goes back, what are we in 2024, so for at least 100 years. I'll note that the great advances made on behalf of the Black Civil Rights Movement in the United States in court were entirely privately financed by donors and by charitable trust funds established by wealthy donors in the United States. The signature cases that advanced desegregation of the U.S. universities and the U.S. public school systems, there was no similar Court Challenges Program. There was no similar federal funding of any of those cases. So it is certainly possible. There's lots of examples around the world. Most of the examples of public interest litigation against government legislation or government policy in the world with functioning constitutions. It was relatively recently, and only in Canada, that was financed with the support of government subsidies like this.
Mr. Brody, like Tuesday, could you mute yourself after the answer? And to our other guests, so when you are asked a question, you can answer it, and then after, could you mute yourself? And then if there's a second question to you, then you can answer it. So it's just feedback issues that we're having here. Mr. Brody was reminded today because it's Tuesday, but for the rest of you, when you answer a question, just put yourself on mute after you answered it and then come back on after. Mr. Gord, we did stop the clock. You have a total of 51 seconds left. Go ahead.
Monsieur Brody,
Mr. Brody, should the program be more transparent? Currently, it's being administered by the University of Ottawa, but we don't know how many organizations are receiving funding and how much funding they're receiving. We don't know what the cases are. It could be 4 organizations in Quebec, and we wouldn't know. Do you find that fair or reasonable?
Absolutely, Mr. Chair. The Court Challenges Program existed for almost 20 years. When it had to disclose who it funded and how much money it sent to each court case. I know there's some argument at the last committee meeting about that, but I think that's a policy that should be returned under future contribution agreements. And if the law is going to be amended here, it should be clear that that'll be a requirement on the Court Challenges Program.
Thank you, Mr. Brody. Thank you, Mr. Gord. We'll go to the Liberal Party now, and we have Mr. Noor Mohammed for 6 minutes. Go ahead.
Thank you, Mr. Chair. And I'd like to thank the witnesses for being here. I'd like to start by asking Mr. Jensen a couple of questions to you. From 1984 to 1993, during progressive conservative governments, there were 24 equality rights challenges that were brought before the Supreme Court. In that, of those, 9 had party or intervener status that were funded by the Court Challenges Program, and the vast majority of those were successful. These are important. I think these are important things to note because I would argue had those organizations or those challenges not been funded, they would have never seen the light of day. What is the impact, if you could briefly give me your assessment of what the impact would be had programs like those in that era not had the funding from the CCP to advance equality rights?
Thank you so much for the question. I mean, I think the question has laid out the key factors at play, which are really that the Court Challenges program facilitated access to the courts and continues to for groups and voices that are not properly adequately represented otherwise and whose perspectives wouldn't reach there otherwise. And with respect, I think that it is actually critical that there is federal support for, in terms of establishing functioning checks and balances within a robust constitutional democracy, that there is support for the bringing of challenges to test the constitutionality of legislation and to have that done before the appropriate body in our system, which is the judiciary. So we have to understand that, of course, the federal government provides extensive funding in defense of legislation. It funds the court system. And what we're talking about with the Court Challenges program is a very, very modest amount of money that facilitates an opening of the door to groups that might otherwise not be able to be there. And so during the period of time that you're speaking to, this was when the courts were grappling with what did it mean to recognize sexual and gender diversity? What did it mean to recognize the rights of women? What did it mean to recognize groups of people that hadn't been at the table in historically? And so it was critical in our understanding as a country and the development of our constitutional law in a way that recognizes all of us.
Thank you, Mr. Jensen. Mr. Chair, during my time that I still have, which I think is about 3.5 minutes, I'd like to put forward a motion pursuant to Standing Order 1082. The motion reads that the committee undertake a study of no less than 4 meetings to study the concerning rise in far-right extremism in Canada, that the study include how far-right extremism plays a role in misinformation and disinformation, how to better support preventable measures for ideologically motivated extremism in Canada, and the connection between far-right extremism and harassment towards journalists, women, Indigenous peoples, Black and racialized communities, members of the 2S LGBTQI+ community, and religious minorities. That the committee reports its findings and recommendations to the House, and that pursuant to Standing Order 109, the committee requests that the government table a comprehensive response to the report. Mr. Speaker, I have the motion translated in both languages, and I request unanimous consent of this committee to adopt the motion.
Mr. Chair?
Can you do that? It was not in order. There's no notice.
And Mr. Chair, the
Was it
clock has
just on-
stopped also, eh? Yeah.
What did you say at the end, Mr. Noor Mohammed?
Unanimous consent to adopt the motion.
So we don't have the 48 hours notice, as
Correct.
you know.
That's why
so-
I'm asking for unanimous consent.
Okay, do we have unanimous consent? No, we do
Mr.
not.
Chair?
Yeah, Ms. Ashton, I believe. I
Yes.
don't know if it was you. Your hand's not up, but I did hear your voice.
Oh, it was.
Go
Sorry.
ahead.
I think it timed out. Yeah, I had my hand up before the conversation with the clerk. I didn't want to interrupt, but I did want to make an amendment to the motion. So
I'll just raise a point of order.
I'd like to do that, recognizing that obviously you were in discussion.
Yeah, we are, Ms. Ashton. I'm going to go to Ms. Thomas as a point of order here. Ms. Thomas?
Thank you. Just seeking clarification. So this motion hasn't been tabled,
It has not been tabled.
and therefore an amendment cannot be moved to a motion that has not been tabled. I would just seek clarification from the clerk on that, just to confirm.
You're correct.
Then Ms. Ashton would be out of order right now.
Out of order. Sorry, Ms. Ashton, you would be out of order. You do not have UC motion on this. When I asked...
I'm sorry, point of
Sorry, who
order.
didn't- I'm sorry, go ahead.
Go ahead, Mr. Cole.
That wasn't a very, you didn't ask the question very clearly, and I did not hear anyone say yes or no. So please, Mr. Chair, can you ask the question again?
Mr. Chair, it's already been asked.
So I'm going to ask if there is... Can I finish for once? Mr. Koto asked me to make a ruling here. Do we have unanimous consent, even though we did not receive 48-hour notice on this motion? Yes or no? No. So we don't. So can we move on, Mr. Noor Mohammed?
Mr. Chair, can I?
Yeah. Now,
Can I speak to what just took place?
yeah.
So here we have a very simple motion.
Point of order.
And-
Point of order.
Point of order,
The
Miss-
motion was not moved. We should go back to
That's right.
I'd like to ask a question, if that's okay,
This
Mr.
is not
Chair.
in order. This is not in order.
So
Mr. Chair,
we've
would it be
done,
possible for me to ask a question?
not on this. We've had the vote and someone said no. So we're going to move on now with the remaining 2 minutes.
Point
and
of
20
order then.
Point of
Mr.
order,
Chair.
Mr. Coteau.
I just want to make it very clear that a motion was asked to study
And it was turned down.
items like far-right extremism, and the Conservative Party said no.
Mr. Coteau, we're going to move
I just
on
want
now.
I just want to make sure that's what
fine.
happened.
We're going to
It's
move on right
a point
now.
of clarification. Is that right?
We had the vote, Mr. Coteau. We've asked it. Somebody said no. And now we're moving on. 2 minutes and 20 seconds left, Mr. Noor Mohammed.
Mr. Chair, I
With
just
your
asked you. I just asked a question.
Yeah, and I'm
that's
just
all.
telling you
Yeah.
what happened here. I've asked if there was unanimous consent. There was no. So now we're moving on for 2 minutes and 20 seconds.
Okay, thank you.
Is that fine?
Thank you, Mr. Chair.
Thank you.
Thank you, Mr. Chair.
2
and
minutes, 20 seconds
Thank
left.
you, Mr. Chair, and I'm sure that the blues in the video, Mr. Koto would confirm that Ms. Thomas, Mr. Lawrence, and Mr. Gord specifically said no, and Mr. Gord held up a sign saying no as well.
Mr. Noor
so it's all
Mohammed,
recorded, Mr.
please.
Mr. Chair, I have the floor.
Yeah, and go.
And you've interrupted me now, so I'd like
I
my 5
haven't
seconds
interrupted you because I've
back.
asked
So
you
I'd
to
like my
continue.
now 10 seconds back, Mr. Chair.
You've got it.
Thank you very much, Mr. Chair.
Away you go.
Thank you. I'd like to now go back to Mr. Jensen. Mr. Jensen, you raised a really important point about the validity. In your comments, you spoke about the defense of charter rights and the importance of defending charter rights. Last week, the leader of the opposition, in speaking about charter rights, said that he would use the notwithstanding clause to override civil liberties and minority rights. Can you speak to the concern that your organization would have about that, and what Canadians should be worried about in the context of what we're talking about today, of when a leader of any political party talks about using the notwithstanding clause to take away minority
Hold on.
rights?
Point of order here, Ms. Thomas. We'll
Sorry.
stop the clock.
Mr. Noor Mohammed just threw out an accusation that actually is not substantiated. He's putting words in the leader's mouth. And so I would just ask through you, Mr. Chair, that he stick to the facts.
Thank you, Ms. Thomas. Yes, Mr. Noor Mohammed, please continue. Stick to the facts of our guests here today. And on Bill C-316, if you don't
Mr.
mind.
Chair, I get to ask the questions, not you.
Yeah,
And I just
but
asked the question, I've asked the witness to answer.
I also get to rule. And when you're kind of crossing the line, which you just did, I also, as a chair, get to rule on this.
Mr. Chair, I
Okay?
asked a very specific question in respect to the testimony of the witness. Would you like me to repeat the
316.
question?
Go ahead.
The witness, in his testimony, Mr. Chair, spoke to the importance of defending charter rights and of this program's ability to defend charter rights. My question was a very specific one. When leaders of political parties speak about overriding the constitutional rights that this individual spoke of in his testimony, using the notwithstanding clause, my question to the witness is what are the consequences and what are the implications of the use of the notwithstanding clause to override minority rights, the same ones that he spoke about in his presentation?
So let's move on then. Who was it directed to again? Mr. Kingston?
Jensen.
Jensen? Go ahead, Mr. Jensen, please.
Thank you, Mr. Chair, and thank you for the question. Simply put, it's devastating. It's devastating that we are in a moment in this country where the notwithstanding clause is being used increasingly to limit the rights of the most vulnerable members of our society. Our position at EGAL is the same with respect to the notwithstanding clause as it is with respect to the court challenges program, which is that it is for courts to determine the constitutionality of our legislation and that it is critical for our society to be protective of all of its members, that the courts retain that role.
Thank you, Mr. Jensen. Mr. Chair, I believe I have about 1 minute left. Perfect. Thank you, Mr. Chair. Mr. Jensen, I'd like to go back again to a period of time when the court challenges program was cut by the Harper government, and you've heard Mr. Brody speak as well. What were the implications, or what has been the impact on minority communities, the LGBTQ2S plus community, and other communities when they don't have access to that funding? And what were some of the specific interactions that you might be able to speak to during that time that curtails substantially the rights of minorities to defend themselves?
Thank you for the question. I may not be able to point to specific examples during that period because I wasn't yet in my role, but what I will say is that I cannot emphasize enough the barriers that exist in accessing the court system in general. And what it means is that marginalized communities are simply without recourse. So as all its members will appreciate, and as other witnesses have spoken to, litigation is tremendously expensive. The Court Challenges program makes a dent in that, but does not support all of the funding by any stretch. And it simply means that rights can be violated by a majority government with no recourse for the minority. So again,
thank you, Mr. Jensen. We're over time now. And thank you, Mr. Noor Mohammed. We welcome from the block, Mr. Beaulieu. Welcome for 6 minutes, sir.
Merci, Monsieur le Président. Merci.
Thank you, Mr. Chair, and thank you to the witnesses for being with us. My first question will be for Mr. Brody. You wrote that the Court Challenges program allowed for federal funds to attack the Quebec legislation. Do you think it is still the case?
The Charter of Rights obviously applies to both the in the federal jurisdiction and provincial jurisdiction as well as municipal jurisdictions. I think I can speak to the history of the program. I think it's clear from the cabinet records that have now been released that Mr. Trudeau's government, the Pierre Trudeau government, the first Trudeau government of the first Trudeau, was seized of the issue of Bill 101, or what we now refer to as Bill 101, the Parti Québécois language legislation, was concerned that parts of that language legislation were unconstitutional or would cause other problems for the federal government. Considered simply launching a challenge, having the Attorney General launching a challenge on behalf of the federal government. I think it's clear also from those records that the federal government cabinet considered using the disallowance power to disallow the legislation altogether. That it found it in its political interest not to pursue either of those avenues for challenging the legislation. And therefore, the Court Challenges program was originally conceived of as a way of achieving what either disallowance or a lawsuit on behalf of the federal government against the government of Quebec would achieve, but without incurring the political costs that a direct challenge or direct use of the disallowance power would have.
Et question, dans le fond, le Québec.
Quebec is a minority nation. Is it fair that the Canadian majority can be submitted to the CCP, which would take apart this Quebec legislation?
Tout le monde peut répondre.
Anyone could respond.
Mr. Chair, I think in responding to Mr. Gourd, I made my views clear on the use of the federal spending power to challenge provincial legislation here.
Merci. Juste une...
Thank you. We know that the CCP and that it arrived in 78, 1 year after Bill 101, and went against the French Charter. But the Quebec government recently established legislation to strengthen Bill 101, and the CCP's budget has been, or was doubled in 2023-2024. And so is there a link there to be seen?
I don't know. I don't follow the debates about language legislation in Quebec any further, and I suspect there's other people testifying today that might be able to better speak to that. I'm afraid I'm not in a very good position to respond.
C'est bon. Ma prochaine question s'adresse...
My next question is for Ms. Roy. And we want to clarify that we're not questioning the relevance of the program for Quebec and Acadian and Francophone communities. But how could we ensure that the program is used to serve Francophone and Acadian populations without weakening French in Quebec?
Merci pour cette question.
Thank you for your question, Mr. Beaulieu. As you know, at the FCFA, we represent the 2.8 million Francophone Canadians living outside of Quebec. And for these people, the CCP was essential to the health and survival of their communities. And so that's what I would have to say today. We know that the program does not share how funding is allocated, how much funding is allocated. These are public funds, and it's quite disturbing. I know that the FCFA had comments, but if there was to be a disclosure once cases are concluded, would you be opposed to that additional transparency? We always support transparency for national programs. The CCP, as it is, does publish yearly reports and has a stringent accountability structure. And so what is shared regarding the program is enough for now.
Oh, you, 6 minutes is up. We'll go to the New Democratic Party. Ms. Ashton, please, for 6 minutes.
Merci beaucoup à nos témoins. Thank you to our witnesses. Ma première question, c'est...
My first question is for Ms. Roy. You explained progress for Francophones in Canada thanks to the Court Challenges program. I would like to come back to 2006. What would happen if the Canadian government decided to stop all funding of the CCP, as was done by Stephen Harper, former Prime Minister in 2006? Graham Fraser, former Official Language Commissioner, stated that this violated the Official Languages Act. What would be the impact for Francophone rights if the CCP were to lose all of its funding? Thank you for your question, Ms. Ashton. I know that time is limited. I agree with what Mr. Jensen responded to a similar question earlier. It would be a devastating result for Francophones. The Francophonie is very varied and includes racialized people, members of the LGBTQ community, and these people are always fighting for their rights. We want to ensure equal access to justice for all of these groups. The CCP serves our communities and is very important. And the program needs to be maintained and needs to continue. Thank you for your clear answer, Ms. Roy. And thank you for the clear examples that you shared of progress that happened thanks to the program and how it strengthened communities and increased access to education in French. My community, in fact, benefited from such a program.
To Mr. Jensen, we are in a committee where we've heard from now a number of witnesses as to how critical this program has been, including from yourself. In fact, I first got involved in politics because of the fight for gay marriage, and recognize the longstanding struggle that EGAL and other organizations have made to make gains, whether it's through the courts, in our parliaments, etc. But we hear loud and clear to what extent the court challenges program is critical to the work that you do and the struggle for justice when it comes to LGBTQ rights. We're also in the context of a committee where we've heard from Mr. Brody, who was Prime Minister Harper's chief of staff when the Conservatives last decided to abolish the court challenges program. So I think it's pretty clear indication that the current group of Conservatives would repeat the same mistakes Stephen Harper did. And I want to quote from his book, Friends of the Court, where he dismissed the court challenges program, reducing its role to one of community outreach to encourage litigation and create new interest groups, as if communities standing up for themselves is just community outreach. He even described how the charter has led, quote, unions, Native groups, language minorities, gay and lesbian groups, and others, end quote, to import American-style public interest litigation techniques into Canada. I find these comments profoundly disrespectful and miss the point of what makes Canada unique and the way forward that we ought to be pursuing when it comes to justice. It's not American-style politics for communities fighting back for their fundamental rights. If we want a better example of importing American-style politics into Canada, I think we could look at the pro-billionaire, anti-LGBT, Islamophobic, anti-Indigenous, and the policing of women's bodies kind of politics that we've seen from Trump and other right-wingers coming out of the States. And we're seeing so much of that in today's Conservatives here in Canada. But bluntly speaking, the elimination of the court challenges programs sets communities back in our country. And it's clear what the Conservatives want. We need to enshrine this program. That's what this bill is all about. What would the elimination of the court challenges program mean for the communities that EGAL fights for?
Thank you for the question. It would mean the further marginalization and elimination of the ability to assert their rights in court. And I think you named just how broad of an impact that would be. So of course, I'm here focused in large part on the communities that EGAL represents. But as I said in my remarks, our position is politically neutral. We believe that Canada, as a constitutional democracy, requires robust checks and balances in the system, and that the rights of minorities, unpopular opinions, unpopular social groups should not be left to majoritarian rule. That's not how our system is set up. And this is a small step that the government has taken that we think needs to be protected to make sure that check and balance in the system stays functional. So in order to ensure that our constitutional rights belong to and can be enjoyed by all in our country, the Court Challengers program needs to be protected.
10 seconds left.
Thank you, Mr. Jensen. Any final words to the committee about how important this bill is?
I simply would just reiterate how our position that it is critical that the Constitution exists for all of us, not simply those who are in favor at a particular political moment. And this program is a critical check and balance to ensure a robust constitutional democracy.
Thank you, and thank you, Ms. Ashton. Second round, 5 minutes long. Conservative Party, Ms. Thomas, you're up.
Thank you, Chair. Mr. Brody, just a quick question here for you to start off with, and that is, it's clear that with regard to this program, the Court Challenges program, there's no specificity in terms of how directors and officers are selected, and there's no transparency as to that process. Should it be specified, and should it be transparent, and why or why not?
Yes, I tried to set out in my written submission to the committee from a week ago. The Court Challenges program has been on this kind of roller coaster existence of being created, being abolished. The Harper government announced, but never did abolish the Court Challenges program. The Court Challenges program has continued on since 1994 in various forms. part of the challenge that the Court Challenges program as an organization has, and part of the challenge that the groups who get subsidies from the Court Challenges program have, is that it has such a narrow political and over time partisan base. And so the written submissions that try to make the argument that the program can be stabilized by bringing the parties of the House of Commons into the governance structure, not by having them, answer to Parliament, but by having each of the parties nominate people for appointment to the Court Challenges Program Board of Directors in an effort to broaden out the scope of the organization and therefore presumably broaden out the funding of the Court Challenges Program. I would just note that over the course of the past 3 years now, we went through a period of extraordinary repression of basic civil liberties and provisions of the Charter of Rights under the rubric of pandemic response. Whether that is a legitimate use of government power or not, I'm not getting into that here. All I'm suggesting is there were a variety of groups and individuals who challenged a number of the COVID era rulings by both the provincial government and by the federal government, all of which were privately financed as far as I can tell. Certainly the Court Challenges Program has not released any details of funding they gave to any of those challenges. None of the groups represented here or before your committee in these hearings was involved in any of those challenges. Those were issues that were legitimately brought before the courts and were entirely financed by private fundraising efforts. If the Court Challenges Program, if we're going to stabilize the Court Challenges Program into the future, I think the Court Challenges Program has to broaden itself out into financing some of these types of challenges as well.
Mr. Brody, thank you very much for answering that question and for giving such a thorough account. At this point in time, I wish to move a motion.
Go ahead.
Thank you, Chair. Notice was given of this motion on April 18th, and the motion reads as follows. Given that, according to a National Post article published on April 17th, a York University faculty committee has presented a list of anti-Semitic recommendations that include labeling the support of Israel as anti-Palestinian racism, classifying anyone who supports Israel as anti-Palestinian, Islamophobic, and anti-Arab, granting academic freedom and free speech to pro-Palestinian students while revoking these same rights from Jewish students and anyone supportive of Israel, and identifying Zionism as, quote, a settler colonial project and ethno-religious ideology that should be isolated and destroyed. And given that the Government of Canada has committed to the Canada Anti-Racism Strategy, and given that the Minister of Canadian Heritage is responsible for, quote, fostering and promoting Canadian identity and values, cultural development, and heritage, and given that the 2024 Canadian Universities Anti-Semitism Report highlights the serious problems of our universities have with anti-Semitism, anti-Zionism, and anti-Jewish hate, I move that the committee unequivocally condemn the anti-Semitic conduct of this faculty committee at York University and that this matter be reported to the House. Chair, I think it's important to note that the motion that I've just read into the record, it does call on this committee to unequivocally condemn the anti-Semitic conduct of the anti-Jew faculty committee at York University. I gave notice of this motion on April 18th. However, since then, in just those few weeks, anti-Jewish rhetoric and actions taken on campuses across this country have only grown in number. In fact, it's out of control and altogether vile and disgusting. It is inexcusable, and this committee has an opportunity to do something about that. Jewish students should not fear going to class or writing their final exams or attending their convocation, but that is in fact where we are at as a country. Anti-Jew mobs are active at the University of McGill, University of Ottawa, Western, Carleton, and now, as of this morning, the University of Toronto. This government has signed off and committed to the Canada Anti-Racism Strategy, which is led by the Minister of Heritage, and it is incumbent upon her to abide by her mandate. So today, we have another opportunity here at this table, and it seems an opportunity that should elicit the collaboration of those here. The hatred facing Jews in Canada should be condemned in the strongest terms possible. We cannot sit idly by and be silent, as those within our community are suffering. So I sincerely hope that my Liberal colleagues especially will not try to water down or equivocate the motion that I'm moving and its purpose to help Jews who are experiencing real terror. All of us should agree that it is wrong to perpetuate hate toward the Jewish community in Canada, which is why I was confused and grieved as to why my desire to seek unanimous consent to see the motion moved and adopted at the last committee meeting was rejected. However, it does remain tabled, and so I do wish to move it today. I remain hopeful that my colleagues across the way will have had a change of heart and perhaps see the light and vote in favor of this motion. And so I would ask that it be voted on at this time.
Thank you, Ms. Thomas. Mr. Coteau.
Well, thank you very much, Mr. Chair. And, I think that everyone at this committee agrees that in this country there's no room for hate. The member opposite who proposed this, just said that she hopes we have a change of heart at this committee. And I want to bring some clarity to this because when it was first introduced, I think it was about a week and a half ago. Is that correct, Mr. Chair?
18th of
April. So we were in the middle of and I got some phone calls and I had some emails and some text messages about this because immediately after it was introduced, the member opposite, went onto social media and made the claim that we were standing in the way of fighting anti-Semitism. And it was really disheartening for me as someone who's dedicated most of his professional career in politics to fight racism and all forms of hate. The member, and I just want to bring clarity to this issue because, we're not playing games here. This is real life situations where people are hurt, people are being discriminated against, where people are, the level of just the toxic level of hate is rising in this country. And I need to speak to this because what happened a week and a half ago when the member introduced this in the middle of a study we were doing, I believe it was a study, out of nowhere. And in the motion, there were some questions that one would naturally ask. Like, for example, it makes reference to policies at York University. I have never seen these policies at York University. I know that there's a current lawsuit. So I did some research. There's a current lawsuit that's being aimed at York University about this issue, and there's probably lots of documents that speak to these issues. So to ask, for the member to ask me to condemn a university without seeing any of the information, like this is a National Post article that I saw that she made reference to. The first time I ever heard of it, the day that she introduced it, the member opposite introduced it.
Just a point of order, Mr. Speaker.
Point of order, Ms. Thomas.
Thank you. Just for the record, the motion asks to condemn anti-Semitism. I noticed that the member across the way refuses to use this word. He's accusing me of wanting to condemn people. That's not true at all. That's not what this motion says. It says that it condemns anti-Semitism.
Thank you.
Mr. Speaker,
go ahead.
It's interesting. I can say anti-Semitism 100 times over. In fact, I was the Minister for Anti-Racism in the province of Ontario. I was the first person in this entire country to embed anti-Semitism into legislation. Ontario was the first province in the history of this country, and I believe BC is the only second province that has anti-racism legislation. And I was responsible for putting that term, along with anti-Black racism, Islamophobia, and many different elements, anti-Indigenous hate, into a piece of legislation that exists today that compels the current Ontario government to build an anti-racism strategy, to collect disaggregated race-based data, to work towards collecting hate-based data. In fact, I had a special advisory committee made up of very prominent members of the Jewish community that personally advised me on this piece of legislation. So to hear the member opposite actually say I'm afraid to use that term. My entire track record of my career at the provincial level, being the Minister of Anti-Racism, spoke to these issues. And you can go through any type of check into the work I've done. I built the first anti-racism strategy for Ontario. And in fact, when I was a school board trustee, I was the first person to bring forward the collection of disaggregated race-based data back in 2006. So these issues are not new to me. I've gone to universities a decade ago to speak to Jewish students, to Muslim students about hate on campus. And by scoring political points in a committee like this, by taking one specific National Post issue article and using it out of nowhere to try to separate and create a wedge between members here, we won't allow that to happen. We are very concerned about hate in this country, the rise of hate. Since 2016, we have seen a drastic increase of online hate. We've seen a drastic increase of hate incidents, and it continues to happen in this country, and it's dividing us. I've been a victim of racism. I've been impacted by extreme forms of hate by people in this country, and I've dedicated my entire life in politics to fighting hate and looking for ways to create balance in this country. We want to look for ways to ensure that our Jewish friends, our citizens, our Muslim friends and citizens, Indigenous communities, the Black community, all people have the opportunity to find success in this country. That's the type of country I'm trying to build. But to use motions like this out of nowhere, without even collaborating with members on the other side to talk about these issues, to look for meaningful ways to act.
Ms. Thomas, point of order.
Thank you. So just for clarification, the Liberal chair actually ruled out of order a previous anti-Semitism motion. And so there really wasn't space to work in a collaborative way, unfortunately.
And Mr.
Otherwise,
Chair,
we would have truly loved to.
It's obvious.
Mr. Cotto, if I could say...
I have the floor, right,
Yeah,
Mr. Chair?
you do.
Yeah,
Can we talk about the motion now? We're going to debate the motion, if you don't mind.
Everything I'm talking about here is about the motion.
Okay, continue about it.
Mr. Chair, we can be responsible politicians at the House of Commons and actually, move forward together as a team of concerned politicians, regardless of the political parties that we're in, and really look for ways to denounce racism, denounce systemic racism, to reveal the history of the atrocities that have occurred in this country against Indigenous people, that continue to happen to Black people. I'm part of a group of people that were on this continent were enslaved, who didn't have the right to vote in many parts of North America, not even several decades ago. So there's a long history in this country, and I think as parliamentarians, we need to remove the partisanship and look for ways to come together rather than to separate ourselves. The leader of the opposition, and this is such an important part because it speaks to, and I don't want to say it in a way where I'm using race or racism to put down the leader of the opposition, but the leader of the opposition found himself in a very awful situation. He came up to a camp, and he saw some signs that brought him there, and he got to that camp, and he saw a symbol that was connected to white supremacy, white extremism, and he probably made a mistake because I don't think the leader of the opposition.
Point of order, Mr. Chair. I think that we could get back to the motion. You seem to have strayed, and you might also speak a little less loudly to protect the auditory health of interpreters.
Thank you, Mr. Gord. Yes, we're debating here the notice of motion by Ms. Thomas.
Yeah. So I want to continue talking. I want to stick to this, but
Thank you.
And I was just about to say, Mr. Chair, that, and before the member spoke to an important issue, I believe I caught the end of it. It was about the interpreters, and the making sure that we maintain a volume level. So I agree with that, and I thank the member for that. But the leader of the opposition had an extraordinary opportunity to rise to the occasion. This is why I'm bringing this up, because I think we have an opportunity as a committee to really rise to the occasion, to really talk about racism in a way that is productive. And the leader of the opposition went to this camp, and he found himself in a very sticky situation. He found himself in a situation where white nationalist symbols were there, and it was a very simple response the leader had to do, and it was just to denounce that specific group, and he has decided not to do that. He's been given,
to the motion.
And Mr. Chair, we're talking about, there's a motion on the floor talking about anti-Semitism, hate, and I think we need to talk about, need to talk about the state of affairs in this country and the state of affairs in politics in this building, in the House of Commons, and the relationship between the parties. I have dedicated my political career to looking for ways to balance the playing field for all people. So I would strongly agree to do a study on anti-Semitism, Islamophobia, anti-Black racism. I would love to do a study that focused on how it's impacting young people. I would like to look for ways to collaborate with the Conservatives to really, flesh out some of this ugliness we're seeing in this country. But I think that if we're going to, use these motions in a way to create divides, and this is, I'm getting to my main point here. So the member last week and a half ago, when she introduced this without notice, immediately, and this is why I say there are political games being played, the member immediately had a prepared statement in front of her that she read from. And it started off with, "I am deeply disappointed with the Liberal Party," and she read from that like it was an orchestrated, engagement.
Point of order.
And
Okay,
in fact, Mr. Speaker,
Just hold on. Point of order. Ms. Thomas?
Thank you. While I appreciate the member's desperate insinuations, there was no piece of paper in front of me. He's accusing me of something, and so if he has evidence that he'd like to present to the committee, he's more than welcome to through you, Chair. But otherwise, he's out of order to throw such accusations against me, and I would ask that you would call him into line.
Yeah, okay. Can we talk about the notice of motion?
did she just say called me into line? Chair, the member should not be suggesting that I should be called into line. She's not the boss of me. She's not my captain. I'm not in the army. She shouldn't suggest that I should, be called into line. That's not I don't think that's a proper term. Now, I want to keep going here, Mr. Chair.
Yeah, are you?
I still want to. I have lots to say.
Yeah, I take
So,
that.
not
but
only-
can you talk about?
I'm talking about this motion and
This
how it
is
was
what we're
introduced.
talking
Yes, I'm
about
talking
right
about
now
the motion.
among the faculty group at York University.
So,
Now,
in
or do you
addition-
have an amendment to bring forward on other issues?
Mr. Chair, I'm speaking specifically about the introduction
York?
of this
Yeah,
motion.
good.
So in addition to that, when it was introduced yesterday, or a week and a half ago, it was like it was pre-planned, because immediately when you asked for unanimous consent, you turned directly to the Liberals, Mr. Chair. And I've never seen this. I have never seen this at this committee or at a committee, and I called you out on it. So it was like it was a coordination, and I'm sure you guys meet beforehand, and this was all discussed. I could be wrong. I could be wrong.
You are wrong.
I'm sure that.
Okay, Mr. Cotto, I said at the moment, I was just sitting in this chair for the first time as the regular chair went to Australia. Do you want me to talk about that, leaving to go to Australia during a week when we sit in the House of Commons? Okay? I did not say that. I sat in this chair. You know how regularly I'm in this chair. I said to you that day, I made a mistake. I said that to you. So are we going to continue on with the motion in front of us for Ms. Thomas? We have others that would like to speak to it.
So, Mr. Chair, I was a
Point of
little bit
order,
taken back.
Mr. Chair.
Ms. Ashton, is this a point of order?
Well, I'm concerned that you as chair have challenged the our regular chair and her motives, frankly, going after her reputation.
Thank you.
You know, as a member of this committee and as a parliamentarian, I'm quite concerned that we're even going down this path. I feel like that kind of approach is just not befitting of any chair. I mean, to know where the chair is, you know, who knows what the personal circumstances are. This is a public meeting. It's simply not okay.
Thank you, Ms. Ashton. Go ahead, Mr. Koto.
Thank you very much, Mr. Chair. And, you know, after the meeting, when this motion was introduced, the notice of motion, you asked for unanimous consent, I went back to, you know, to where I stay when I'm in Ottawa, and I was flooded with emails and phone calls because the way in which it was written that, you know, I wasn't even I wasn't even in the room. I wasn't even here. Actually, I was virtual, and I couldn't tell who said, like, what was said, you know. But the first thing is I was identified by Ms. Thomas on her social media, and she said Koto. You know, she tagged me as @Koto. Has just basically, I don't want to read the email, but I mean the text, but it's something to do with, like, you know, I stood in the way of anti-Semitism. I want to say right now for the record that I am...
Point of order.
Point of order, Ms. Thomas?
I wish he stood in the way of anti-Semitism. It would actually appear that the member supports it.
Stood in the way... It's fine.
Mr. Koto, continue, please.
Stood in the way of fighting anti-Semitism. Okay, so the member put this out. It was very political. It was very misleading. It was very charged. People were calling me. I have friends in the Jewish community that I've worked with for 20 years, fighting anti-Semitism, who called me and said, "Michael, what's going on?" And you know what, Ms. Thomas, she occupied 8 hours of my time afterwards, phoning people, constituents, explaining what happened, that unanimous consent was asked for a motion that was never shared with this committee, that came in last minute when we were doing a study without any attachments of what policies they were talking about, asking us really to, and the way I read it, you know, calling out York University and for its policies. I don't even know what the policy was. So it was very misleading. It undermined my efforts over the last 2 decades fighting hate and anti-Semitism and Islamophobia, anti-Indigenous hate, anti-Black racism. And I was just, you know what, it was really difficult, Chair. So what I would like to ask the member opposite is, can we come together in a meaningful way to look for a way to really, because there are students on our campuses, Jewish students, Muslim students, and students who are there fighting for different causes, and it's all, you know, it's all fought in many ways to look for ways to fight for equity and equality and fairness. Like, people really believe that they're looking for ways to make the world a better place. And there's deep divides on each side, but we need to look for ways as politicians to bring people together.
Point of order.
Point of order, Mr. Lawrence.
And I would go back. I know we're given a wide latitude, and this is, I agree, a very important issue. And quite frankly, I congratulate the member for fighting racism, and it truly is a scourge. The reality is he now has had notice. Let's just move to a vote and condemn anti-Semitism like we all should.
Thank you, Mr. Lawrence. Go ahead, Mr. Koto, if you can.
Thank you very much, Mr. Chair. And thank you for the kind words, Mr. Lawrence. I have been looking for ways to fight hate for a long, long time. My point was this, is that we should come together, and I don't mind reaching into the other side and working together and pushing away our partisanship You know, because in politics it can get pretty rough sometimes, and the divides are strong. But when it comes to racism, when it comes to Islamophobia, when it comes to anti-Semitism, you know, we need to hang up our political colors, our stripes, and we need to look for ways to work together. When we put motions on the table that are designed to create wedges, what it does, it actually starts to impact people in our communities.
Ms. Thomas?
Sorry, through you, Chair. Again, I just would ask, I understand that the member likes to throw accusations my way and insinuate why I would do something. My motives were pure. I believe that the Jewish community is under attack in this country and that we need to stand for them. This government has put forward an anti-racism strategy and they need to abide by that. Mr. Chair?
You know it's not a point of
I would
order.
ask that the member opposite watch his words very carefully and
here
not
we go
attack
again.
me as a member across the way by insinuating my motives. I think that's a fair request at this committee.
Thank you, Ms. Thomas.
Chair, when I said
Yeah.
when we put motions
Yeah.
together that are designed to create wedges, I did not mention anyone's name. I just said that we as politicians have a very, I think, an obligation, a moral obligation to rise to a certain sense of decency when it comes to issues like hate. So I would just say that, and I'm going to end very shortly, Chair, and just say that as we continue this conversation right now, as we start to debate this motion, that we look for ways to actually work together. We look for ways to build an approach that speaks to the many issues that occur out there. And I'm willing to just lay down, you know, those political gloves to, you know, bring forward a more humane, humanitarian effort towards building a solution going forward. Because I actually think that politicians can help when it comes to fighting hate. Thank you, Mr. Chair.
Thank you for your comments, Mr. Koto. We move now to Ms. Ashton on video. Go ahead, Ms. Ashton. What is the will of the committee here with our guests? Should we let them go? We've got another 15 minutes here. Let them stay and hear this? Okay, we'll let them stay. Go ahead, Ms. Ashton.
Well, thank you. First of all, I want to indicate that I find this motion deeply problematic. First of all, the entire premise is a National Post piece, and National Post has been engaged in some very problematic coverage, well, for some time, but I would say particularly when it comes to hate overall. I mean, the National Post is also well known for supporting residential school denialism, anti-Indigenous racism. There's a piece, I believe, in today's paper that shares deeply racist messaging around a Ontario MPP, Sarah Jama, and engages in both racist and anti-Palestinian racism. And I think we have to be clear. This motion from the Conservatives is not about condemning anti-Semitism. It's about playing their political games. Because if they cared to condemn anti-racism, 30 minutes ago they would have supported the motion put forward, in fact, by the Liberals on studying the rise of the far right, which are pushing, who are engaged in anti-Semitic hate and other forms of hate. In fact, their leader for days now has refused to condemn Diagolon, a far-right organization that also pushes anti-Semitism. He met with folks that support this far-right movement and still refuses to condemn them. And then I will say, this member just this past October, if we're going to talk about condemning hate, came out with the egregious accusation of CBC journalists accusing them of being on the side of terrorism in their coverage of
to the motion,
genocide
please,
in
Ms.
Gaza.
Ashton, to this motion, if you don't mind.
We're all here to talk about the motion, but
Yes,
but I
and
think it's
stick
pretty
to the
clear that
motion, please.
Well, I am because I.
No, you're
because
not.
the
You're talking
Conservative-
about CBC and other stuff, so
With all,
if you
no,
don't mind.
with all due respect, Mr. Chair, I didn't see you cut into other members.
Oh, I've cut in. Ask
as you did
Mr.
with
Koto.
me.
Yeah.
But what I will say is that this is not about condemning anti-Semitism, as the member indicates. I also find it deeply troubling that part of the rhetoric we heard from the member was also in reference to what's happening on campuses across, obviously now North America. I think it's very dangerous for parliamentarians to make accusations like we've heard from Conservatives on that front. What we need to recognize here is in fact, Conservatives love to talk about freedom, and here we should be reiterating as parliamentarians that we respect students and Canadians' freedom of speech, freedom of assembly, including when it comes to anti-war protest, and the fact that many Canadian young people are standing up against genocide and Canada's complicity in it. And so we should be, as parliamentarians, condemning anti-Semitism, along with condemning Islamophobia and anti-Palestinian racism. That is not what today's motion purports to do. And the fact that 30 minutes ago, the same party chose to not look into the rise of far-right extremist hate, to me really undermines the sincerity of the motion ahead of us, indicates that they're keen to get clicks on social media rather than actually get into taking on anti-Semitism, Islamophobia, anti-Palestinian racism, and other forms of hate. I don't think we as parliamentarians have, we need to be genuine in what's being discussed here today. And it's also not lost on me that this is coming up during a debate on the Court Challenges program, which is a program that is premised on fighting for equality and justice in Canada, fighting against hate on behalf of marginalized communities, communities that have been denied justice time and time again. These kinds of political games Canadians see through. Let's be serious and condemn anti-Semitism, Islamophobia, anti-Palestinian racism, and also support very clearly the right to freedom of speech, freedom of assembly that students and Canadians have, and stand up against all forms of hate. I will leave it there. Looking forward for a productive discussion on this front rather than scoring political points at a time of a very serious time in our country, particularly given the genocide happening in Gaza, the fear that Jewish communities face, Palestinian communities face, Muslim communities face. We should be doing them justice by putting forward a motion that has a greater intent, and I would say it seeks to really take on the kind of hate that we are seeing across the board in our country. And I look forward to having a discussion on that.
Thank you, Mr. Ashton. We'll go to Mr. Noor Mohammed on my list. No? Okay. So I have you, and then I have Mr. Lawrence, and then Mr. Saray. Those are the three I have. You're up right now.
Okay, well, I want to set the record straight, Mr. Chair, in terms of the notice of motion that was brought last time.
Sorry, which last time?
On the 18th.
Okay.
I want to set the record straight because a lot was said in the presentation of this motion today that I believe needs clarification. Mr. Koto rightly pointed out the misrepresentation of what happened in this committee on social media caused harm, caused hurt feelings, caused ill will, and caused the further pain to members of the Jewish community, which is simply unacceptable. So for those across the way that somehow believe any of us are equivocating on the subject, let me speak very clearly. I condemn all forms of anti-Semitism, and all Canadians should. I condemn all forms of anti-Semitism, and all Canadians must. That is who we are as Canadians. There is no place for hate in this country. There should be no place for hate in this country on our campuses, in our streets, in our communities, anywhere. And that, I believe, Mr. Chair, is something that we should be able to all do together, without fancy preambles, without hypotheses, without depending on National Post articles. Mr. Chair, what we should be able to do as a committee, as Mr. Coteau rightly pointed out, is come together and condemn hate, in this particular case, anti-Semitism, the insidious nature of anti-Semitism, be united in that message, because in so doing, what we are saying to people is that this isn't a political football. This isn't a game for people to score points on social media. This is a serious issue facing our country, and that we should let Jewish Canadians know that the fight against anti-Semitism is not their fight alone. It is a fight that all of us are a part of. It is a fight that all of us are committed to. I am not finished, Mr. Chair, and this is...
Point of order, sorry. Ms. Thomas?
Thank you. I'm just confused as to why we're not allowing this to go to a vote if the member opposite is in support of the intent of this motion. Instead, the Liberals seem very
Mr.
much
Chair, that's not a
hell-bent
point of
on
order.
Filibustering.
That's not a point of order, and I was in the middle of saying something.
You've got the floor. Go
Thank you,
ahead.
Mr. Chair. As I was saying before I was interrupted, it's really important to me in the constituency that I represent that they know that the members of my constituency, the residents in my community, understand that their member of parliament stands up against hate, against anti-Semitism in all of its forms. That I am committed to working with all parliamentarians, regardless of their political stripe. And I'm sorry that saying that working with other parliamentarians may cause others some harm, but I think it's important for us to do that. Work with other parliamentarians across political lines to fight anti-Semitism.
Point of order.
A point of order again. Ms. Thomas?
That is exactly what this motion seeks to do. It invites the members.
That's not a
around this
point of order,
table
Mr. Chair.
to
That is not a
participate
point of
in
order.
the
That is
condemnation of
not a point of
anti-Semitism.
order.
And there's been like
Thank
seven
you.
times
Hold on,
in a row.
Mr.
It's been like
Mr.
7 times in a row, and
Yeah,
there's a pattern here.
you don't have the floor, Mr. Koto. Mr. Noor Mohammed, please, to the motion.
Thank you, Mr. Chair.
Thank you.
So I'm going to go back to what I was saying. It's important for members of my community, of communities across this country, to know that we are all in the fight, or we should all be in the fight against anti-Semitism together. It is one thing to protest. Protest is important. It's a part of who we are. But it is not okay for those protests to be anti-Semitic, to call for the deaths of anyone, or to celebrate violence or acts of violence. It's also equally important to make sure that we approach this in a way that isn't about scoring political points. That we recognize that by working together across parties, this is
Ms.
unbelievable.
Thomas, point of order, yes?
So there's an accusation being thrown out there that
There was
political
no
points
accusation,
are being
Mr. Chair. This
scored,
is not a
but
point
the
of order.
Liberals have
Again.
held the floor for over 20 minutes in a filibuster, and so I'm curious as to their motivation, and I would invite them to allow this to come to a vote. So that together
Mr. Chair,
we can
first of
stand
all,
against
Mr. Chair,
anti-Semitism.
we would not be in
Thank
this
you,
situation.
Ms. Thomas, go ahead,
Thank you.
Mr. Noor Mohammed.
For anyone that is
To the motion, yeah.
I want to be very clear, Mr. Chair. I would not have to explain any of this had Ms. Thomas not put on social media things that represented my position and the position of my colleagues. Had this been an honest conversation about the urgent need for all of us to come together in a motion that skipped the politicization and went clearly to the heart of the issue that we need to be talking about, which is the fight against anti-Semitism, we wouldn't be in this position today. I think it's important for us to take out the preambles, the assertions, the value judgments about newspapers being sources, and actually say that this committee is unequivocally united in its support for the fight against anti-Semitism, and that fight is one that must be taken on by all. That is something that I believe every single member of this committee would stand for. What I find deeply troubling is that this is not the first time, Mr. Chair, that some have chosen to use social media to grossly misrepresent the views of people on this side, of others, and to seek to try and foment discord in communities that are already hurting.
Mr. Chair, that's just unparliamentary. I'm sorry.
Mr.
What is unparliamentary, Mr. Lawrence, about saying that we need to work together? Please tell me.
I will. You said that we were fomenting disagreement amongst communities.
Yeah.
That is unparliamentary.
That's not a point of order, and I'm so pleased Mr. Thomas raised that because Mr. Lawrence raised
can
that.
I bring you all back here? Mr. Lawrence, thank you. Mr. Noor Mohammed, the floor is yours.
Thank you.
Can we
Thank
talk
you,
to the
Mr.
motion?
Chair.
Okay.
Mr. Lawrence asserted that my comment was somehow made out of fancy. So let me clarify for Mr. Lawrence in my comments. Immediately after a social media post was made, which completely misrepresented what happened in the room and my position on something, I received letters from members of the Jewish community asking what actually happened, asking why the accusation that Ms. Thomas made had been made. So I spent time, and I'm glad to do this, speaking to people that I care about, my constituents, explaining to them that, in fact, what Ms. Thomas asserted in social media didn't even happen. And so...
Point of order.
Oh, okay. Here we go.
Point of order, Ms. Thomas.
Thank you.
Why is this? Why can't I finish what I'm saying?
Can we just, Michael, can we get to the point of order, please? Go ahead, Ms. Thomas.
Sure. We have a motion on the table. The motion that has been brought forward has to do with anti-Semitism on university campuses.
It's not a point of order.
Right now, the member is spending time attacking me as an individual.
Mr. Chair.
Thank you.
Further to that,
this is not a point of order.
The record
Mr.
that
Chair,
has been stated, which is public,
Mr. Chair.
and so I would invite anyone who
not,
wishes to challenge what has
so
been
we're going to
stated
bring
to
everyone
simply look at
together.
that public
Thank you, Ms.
record.
Thomas. Mr. Noor Mohammed, I'm going to say to our guests, thank you for joining us this afternoon. I'm going to let you go. Some may be called back next Thursday, who knows? But I want to thank all 5 groups that were with us today because we're coming up on 5:30 Eastern Time. Thank you very much for your comments today, each and every one of you. So thank you for being with us. You're free to go as our guests, and we'll continue the debate here with Mr. Noor Mohammed.
Thank you, Mr. Chair. So I was interrupted twice, and I want to make sure that there is clarity. I want to make sure there's clarity because I know that our friends opposite, I'm not going to presume anything. I imagine there is a scenario in which other members may wish to clip what is being said to perhaps yet again show the world what they think is one version of the truth. And I'm sure it may, I don't want to presume anything. What I want to say is this. It is really important for Canadians, Muslims, Jews, people of all faiths, of no faiths, to see parliamentarians able to stand up together and say they condemn anti-Semitism in a motion in this House, if I may finish, thank you, in this space, and do that. So I would make an offer to anyone, including Ms. Thomas, Mr. Gourd, Mr. Lawrence, Mr. Beaulieu, my own colleagues, Ms. Ashton, to say, and you, Mr. Although you're in the chair, so to say, let us seriously park motions that are not necessarily at the heart of this issue, that speak to the heart of the issue. And if we do in camera so we can treat each other civilly, if we want to put each other in camera and treat each other civilly, to actually craft a motion that says unequivocally, Mr. Chair.
Point of order. Point of order.
Because they don't want us to say the thing that needs to be said, right? Don't want to hear what we have to say.
Point of order. Ms. Thomas, go ahead.
Thank you. I'm just not sure why the members opposite continue to filibuster when we have an opportunity
Point of order,
to do
Mr. That is not a
exactly
point of
what it
order,
is that
Mr.
they're
Chair.
hoping to do.
That is not a point of order.
To stand together against anti-Semitism.
It's not a point of order.
We have the opportunity to vote on this right now.
Yeah, thank you, Ms. Thomas. Mr. Noor Mohammed.
Thank you.
I will say this, we have 2 minutes till 5:30.
Mr.
We have
Chair,
10 minutes.
Mr. Chair, I believe if asked in a clear motion that was unequivocal, that didn't depend on things like a National Post article, but actually on the facts on the ground that we are seeing directly from people that are suffering harm, that you would have a committee vote on a resolution that every one of us should vote for.
So are you offering an amendment, Mr.
I would like to. I mean, I haven't even gotten to that part of the conversation yet, Mr.
Have you got one in front of you? I'm asking.
I have not done. No, what I'm trying to say, Mr. Chair, genuinely, as somebody who has spent years of trying to bring communities together. Years of working with the Jewish community in my riding, with the Muslim community in my riding, bringing them together to try and solve problems together instead of pitting people against each other. As somebody who actually cares about this issue, as somebody who has 6 synagogues, 2 Jewish schools, a lot of Jewish constituents who are deeply concerned, as somebody that is saying, that is begging people in this committee to say, for God's sake, for once, let us put partisanship aside, sit together, and come up with a resolution that every single one of us can support. Why is that so difficult? That is what I don't understand.
Point
and
of
if
order.
you want to call this a
Point of
filibuster,
order.
Mr. Chair, that's not what this is. This is
Point of
somebody who
order.
genuinely cares about this issue, saying we need
Point
to
of
find
order.
a way to work together.
Yeah.
Point of order.
Mr. Noor Mohammed. Point of order, Ms. Thomas? Go ahead, Ms.
I don't think
Thomas.
there's been
So
one
I'm
yet,
going to make
Chair.
a judgment
Not
here,
one out of
everyone.
12.
It is 5:30 Eastern Time. We have 10 minutes. We can expand by 10 because really, when we started, it was kind of 3:40. So we can go till 5:40. Okay. Go ahead, Ms. Thomas, again, if you don't mind.
Again, I'm just not sure why the member across the way isn't allowing this to come to a vote so that we can do exactly what he's talking about, which is to work together toward a positive end, which is to stand against anti-Semitism. That offer is on the table, and we can collectively do that right now. Instead, the Liberals have now been filibustering.
Point
for
of
over
order.
30
Mr. Chair, this is
minutes.
not a point of
Thank
order.
you.
This is not a
We've
point of
got
order.
a point of order. I think it was Mr. Courteau. No? That wasn't you. So go ahead, Mr. Noor
Thank you.
Mohammed.
So I just want to be clear. What I am suggesting is that instead of firing amendments back and forth, instead of playing the game of battling motions, let's sit down properly as a group, all of us. This is my request. It is my offer. I would ask Ms. Thomas to withdraw the motion in her current form and say, why don't we sit together, all of us? Because it isn't just a question of York University. This is a question of people in my community and others. People who are walking down the street who are worried about sending their kids to the Jewish day school in my riding. This is a serious issue. And if we are serious about doing this and not having a partisan game, let's go into camera, all of us, let's come up with a motion that can be supported unanimously, and please, let us take this seriously. I don't want this to be a political game for any community in this country. We have serious issues related to hate, Islamophobia, anti-Semitism, anti-black racism. These are all issues that we should rightly be working together to fight. In the case of this conversation about anti-Semitism, Mr. Chair, my request sincerely, and I have a track record that I am proud to stand on in working with the Jewish community in my riding and others. Let's actually do the right thing here. Let's sit together without cameras, without the show of theater, come up with something together that would send an unequivocal message to the Jewish community in this country and to all communities that none of us have daylight between us when it comes to the fight against anti-Semitism. There are too many things in this world that people in this country are being held to account for. There is nothing reasonable about holding Jews in Canada responsible for what is happening in Israel and in Gaza, any more than as a Muslim, that it was right for people to look at me and say, your people are responsible for 9/11. I grew up in an era, Mr. Chair, where Muslims were looked at because of 9/11 and said, you are responsible. You are responsible for what happened. To this day, the number of comments that I get on my Twitter about Taqiyya Tuesday, about people saying, oh, you were a member of Al-Qaeda, you were a member of this, you are the Hamas troop and brigade. These are things that are serious, and they were, Mr. Chair, in response to many of the things that in response to the tweet that Ms. Thomas put up the other day. So I get it. I know what it means when communities are vilified by what happens a world away. I get it. I have lived it. I live it. My family has lived it. It is not okay. It is not okay for Jews in this country to pay the price for what happened or what is happening in Gaza. It is not okay for people to assume that all Muslims somehow support Hamas. These are things that are fundamentally wrong. And so my plea, sincerely, to every member of this committee is let's sit down together. Let's start with a blank piece of paper, all of us. If we truly care about this issue. Ms. Thomas spends a lot of time saying she cares about the Jewish community. Wonderful. That's important. And she should. We all should. But then let's take this seriously. I'm reaching my hand out to say to every member of this committee, let's sit down in a room together. Let us craft language that is unequivocal in its condemnation of anti-Semitism. Let's do that. Let's send a message that protest is fine, anti-Semitism is not. Let's send a message that says fighting for things that we care about is right, but glorifying violence is not. Let's send a message out there that says that no innocent life should be lost in vain, that there should be condemnation of all loss of innocent life. These are things that we all should be able to do. So my question is this: is every member of this committee willing to sit down, turn off the cameras, turn off the social media, and sit together and work like grown-ups, like the people that we are, like the people that we were that the grown-ups that I believe our constituents elected to come together and actually get something done? If that is the will of this committee, if that is the commitment that we are prepared to make, for once, to put partisanship aside, to put the cheap political points aside, and say, let's start with a blank piece of paper.
Point of order.
We know what the issue is, and make Canadians proud. Let's make Canadians proud of this committee, which I believe they deserve to be.
Point of order. We have from Ms. Thomas.
Again, I would just ask the member to stay focused on the motion and not to insinuate motive.
Thank you.
Point of order as well, and I will say this is not a valid point of order, but I do, like, we've got 5 minutes left. I'm the next on the speaking list. The Liberals have had the whole time. If you're serious about having your hand outstretched, let us have 2 minutes of time before.
Thank you, Mr. Lawrence.
That's
The floor right now is Mr. Norma.
No, and look, and
Okay?
I respect Mr. Lawrence, and so I agree with him. And I'm going to end quickly because I do believe I want to hear what he has to say. I do. So I'm going to end with this. This is a committee where, you know, it's pretty easy to score cheap political points. Look, everybody does it. It's fine. We've all thrown motions out there for whatever reason. I don't want to prejudge what people's motivations are. What I do want to say is this. This is serious. This is serious for all of us in the communities that we represent. It's important for us to set an example. When it comes to anti-Semitism in this case, when it comes to anti-Palestinian hate, when it comes to Islamophobia, anti-Asian hate, anti-black racism, we should be able to just say, you know what, this is not partisan, right? Every government, historically, of every stripe has sought to make strides in this regard, regardless of their political party. So my request is this, and I'm going to wrap up. Let's take the opportunity to show Canadians leadership, to put all of everything that has been in the past forward, and let's say, blank piece of paper, let's work together. Let's write a motion that we can all not just live with, but be proud of, that gives the Jewish community confidence that we're going to take this fight on together, that shows other communities the importance of fighting this fight together.
Point of order.
Point of order. Ms. Thomas. Yeah.
Really?
Go ahead. You have the floor.
Mr. Chair, thank you. The proper procedure that
This
the
is
member
not a
needs.
point of order, Mr. Chair.
It is a point of
It's
order
not a
because
point of
order isn't
order.
being followed right now.
not
The
a
way
point
to
of
bring
order.
forward a suggestion, such as what the member is putting, is either through an amendment of the current motion, which he has not moved, though given the opportunity
Mr.
to
Chair,
during
this
his
is not a point
last
of order.
15-minute
This is not a
filibuster,
point of order.
or
It's not a
bring
point of
forward
order.
another motion
Mr.
during
Point
the
of order.
next committee meeting.
That's a good
He
suggestion.
has the
too.
tools.
So I'm gonna
He's
wrap up by saying
refusing
this.
to use them, which makes
Chair,
me question
Mr. Chair,
his sincerity.
This is not a point of order. I'm going to
Okay,
wrap up by saying this.
Mr. Norma, you have said you're going to wrap up.
I'm going to wrap up by,
so-
well, I got interrupted. So I'm going to
Okay.
wrap up by saying this. To at least Mr. Lawrence, who seems to be somewhat interested in what I'm saying. Let's sit down together. Let's craft a motion that does what I believe all of us want to do.
Point of order.
I'm trying to give you my,
Okay,
time.
point of order here. Do you want to request till 6 o'clock here? Or
Childcare.
Yep.
an extension till 6?
I got to pick up my kid from daycare.
Let's go till 6.
Okay.
pick up a kid from
No,
daycare.
okay, no. So, point of order, Ms. Thomas, and then, okay, thank you. Ms. Thomas, point of order.
I would just observe that order is not being followed. The member across the way cannot invite us into a dark room to have a conversation.
Oh, wow.
The member
Okay, so
across
with
the
that,
way
Mr.
can
Chair,
move an amendment
let me-
to the motion that is currently on the floor. That
I would
is
love to end.
that is the correct order
Wow.
that is available
Okay.
to the member
Okay.
across the table.
Thank you.
Okay, so
Let's gather,
So I'm just
everyone,
going to
we
say,
got 2
I'm going to
minutes
say the
left here.
following. I'm going to say
Mr.
the
Nur
following.
Mohammed.
The invitation, there can be any amount of light in the room that Ms. Thomas chooses. Dark, light, lots of lights, no lights, I don't care. What I am saying is let's come together, let's write a motion that every Canadian can be proud of, that Jewish Canadians will be able to stand on, that says that they are proud of
Point
this,
of order.
that we are all fighting
Point
together.
of order.
And with that, Mr. Chair,
Point
I
of
will
order.
cede the rest of my time, and I'm sure Mr. Lawrence has things that he would like to say.
Ms. Thomas. Yep, point of order.
I recognize that the member has finally ceded the floor after filibustering, combined together as liberals
This is not
for
a
the
point
last
of order.
40 minutes.
Again, this is not a point of order, and all
Again,
she's doing is
Mr.
chairing up Mr. Lawrence's time.
So for committee, we are at 5:40 Eastern Time.
Mr. Chair, through you,
Yep.
my point of order, which stands, is that there is a proper order to be followed, which is to say that the member across the way can put forward an amendment to the motion.
Yes.
However, he chose not to do that today. Instead, he
this
held
is
the
not a
floor
point
in
of
a
order.
filibuster,
This is not a point of order.
trying to make
This is not a point
trying
of
to
order.
defend
Not a
himself,
point of order.
and yet offering no support
Thank
for the
you,
motion
Ms.
that is in front of us, which would condemn anti-Semitism in this country.
Thank you, Ms.
Mr. Speaker, point of order. It is 5:40. However, there has not been a motion to adjourn that has been presented at
That's
this
right.
table, and we do have resources to go till 6.
I don't, do we?
That's 2 hours or...
We don't have any resources, Ms. Thomas. We are at the 2-hour mark. So I need an adjournment or a suspension. And keep in mind, if we do suspend, it would affect the May 7th meeting. Yeah.
Point of order. Chair, either you unilaterally decide to adjourn this meeting right now,
Well, I'm
or
going to.
the floor goes to Mr. Philip Lawrence.
I will adjourn.
Thank you.
Thank you.